going to get started. My name is Kyle Patterson. I'm a director here with Bryson Insurance, and beside me is Carole Wallace, and I will introduce her in more detail a little bit later on. But we thank you all for joining on and participating today. I see Kim's already noted that there's maybe something with the PDF, but if you can't download it, follow along and I'll make sure to send that out afterward. This webinar is going to be about 40 minutes in length, and we encourage you to ask questions as we go. Carole's happy to answer them if they flow along. If for some reason we don't answer your question throughout the course of this webinar, Carole's also happy to answer that with you afterward, and we'll reach out to do so. And so again, feel free to ask questions. Now what Kim's pointing to, because she was on early, is at the bottom we have a shared file. It's actually the PDF that we're going to be going through today with the note-taking form. So if you want to download that now, you can follow along with that and take notes as you go. Let's jump right into this. So the webinar today is the impacts of marijuana on the workplace, or in the workplace. So what we're going to cover today is an overview of the current regulatory environment and for both medical and recreational marijuana. We're going to look at the impact that marijuana can have on individual performance, and also get into the thick of what can employers do and what should they do, from things considering like random drug and alcohol testing, fit for duty policy, and also the duty on the employer to accommodate. So why this webinar? Obviously, one big thing is the government of Canada is looking to legalize recreational marijuana. And an interesting study from Deloitte showed that currently 22% of Canadians engage in or consume recreational marijuana. But if it was legalized, 17% more Canadians would also participate. So 40% of Canadians will use recreational marijuana when it becomes legalized. So that is a lot of employees, employers, and just people. The other side of this is, what are the actual employer concerns? Like, why are you on this webinar? So number 1 and number 4 are very similar, but they're big. So employees operating motor vehicles or utilizing heavy machinery under the influence is one side of this. And then on the actual HR side, disciplinary procedures, how does that look? What happens there? What's decreased work performance? How do you measure? And then absenteeism or attendance issues. And so that's what we're going to dive into today. It's now my pleasure to provide a proper introduction to Carole. And I'm actually going to read this because we're sitting with a lawyer today, and we want to make sure we cover this off, because Carole actually has an incredible background and has an astute sort of understanding of the legal practice, and is perfect for this conversation. So Carole Wallace is a lawyer with Fernandez Hearn, LLP. It's a Toronto-based law firm that specializes in the transportation sector. So Carole represents both domestic and international trucking and bus companies on a wide range of transportation matters, including regulatory compliance, defense of provincial offenses, contract drafting, and commercial litigation. On the other side, Carole also practices employment law, and that combination is extremely unique. So she advises both federally and provincially regulated employers in Canada and employers internationally as well on compliance with employment standards, the management of human rights, and on occupational health and safety compliance, including responding to workplace harassment complaints. Carole appears on her client's behalf before the Ontario Court of Justice, the Ontario Superior Court of Justice, the Ontario Court of Appeal, the Ontario Highway Transport Board, the License Appeal Tribunal, and both the Canadian and the Ontario Human Rights Tribunal. So it's at this time my absolute pleasure to introduce Carole.
Thank you very much, Kyle. Good morning, everyone. So as Kyle nicely framed it, we're going to cover sort of 3 main areas. I'm going to talk about where the law is today, what the regulatory framework looks like. I'm going to review with you some of the information I've gathered about the impact of marijuana, cannabis on individual performance, and then we'll get into the real meat of today's session, and that is what do workplaces need to do? What are an employer's responsibilities and obligations in the context of marijuana? So the regulatory framework, currently the law that is in place and in force is the Access to Cannabis for Medical Purposes regulations. This regulation came into force in August of 2016, and it had developments over the previous years to arrive at a regime for medical marijuana only. And this is run by the federal government. It licenses medical marijuana producers, and it regulates the distribution of medical marijuana to individuals who have a prescription. And it goes from producer directly to the patient or to the patient's pharmacy. And that's the regime that's in place that allows individuals to access medical marijuana for those purposes. We know that the government has introduced the Cannabis Act to legalize recreational marijuana. And on my way here today, some of you may have also heard this on the CBC this morning, that there's concern that the Senate may stall the implementation of this bill. There's a vote in the Senate today, and there's some real concerns that some members of the Senate will try to delay the implementation of this act to legalize recreational marijuana, which is supposed to come into force the summer of 2018. We've somehow, through media, got stuck on this July 1st date as a potential implementation date, but there's really no guarantee that that will be the implementation date. And once this act becomes law that's in force, it will govern the production, the distribution, sale, import, export, and possession of cannabis in Canada. And it will allow individuals to possess it, to use it, to grow it, to purchase it for personal use. And I'm now going to need my glasses. It will still be produced by licensed producers. So the medical marijuana producers, and apparently the licenses are growing almost daily. Ontario is one of the hotbeds for medical marijuana production. Those producers will be producing it for the recreational purposes. And then the provinces and territories, it's up to each province and territory to set their own rules and regulations under their own little acts as to how the distribution of marijuana will work and the use of it, the recreational.
Just as a quick question there, are employers able to create their own standards inside of that, or do they just have to follow the Ontario and federal regulation? What I mean by that is, if people are allowed to just carry it on them freely, does an employer have to just allow that in the workplace as well?
No, I think a good analogy is alcohol. Alcohol is legal. You can use it in certain places. You can buy it in certain outlets, but workplaces will often have policies that prohibit bringing alcohol into the workplace, or I know depending on the type of workplace it is, prohibit the consumption of alcohol at lunch, even if it's a social lunch or a celebratory lunch. So the employer can still set its own policies around legal recreational cannabis. If the employer doesn't want it brought into the workplace, that's an employer that has the right to do that.
Great.
So the Ontario Cannabis Act 2017 is the statute that Ontario has developed to govern what we'll do in this province. It will be sold, you probably have all heard about this in the news in recent weeks, that it will be sold in its own location. It'll be run by the LCBO, it's the Ontario Cannabis Retail Corporation. It won't be sold at LCBO outlets, they'll be in separate locations. There's regulations both federally and provincially about packaging. It's going to be very plain packaging. We understand there's going to be warnings on the package, similar to tobacco. And in Ontario, they've set the age for purchase to be 19 or older. And as I understand it as well, edibles are not going to be part of the recreational cannabis legalization. That is something that may be coming, but for now it's going to be the dried or fresh seeds and oils. That's the form of cannabis that will be considered legal once the federal act comes into force. And I also understand that in Ontario, the regulations are going to govern where it can be consumed, and basically it can be consumed in private residences. It will not be allowed in public places. It will not be allowed in workplaces or in motorized vehicles. So, and the motorized vehicles is quite an obvious one when we get to some of the information about the impact of cannabis, whether it's medical or recreational, on one's ability to operate a motor vehicle. So that, and the last point that a lot of people don't realize is the dispensaries, although I've seen a few of them in the city now shut down, they've never been legal. I think they were opened in anticipation that they would be able to sell recreational marijuana, and that's not the way the regulation is going. So they've never been legal. I think it was up to each municipality whether they wanted to enforce bylaws and shut them down. So they're not going to be legal. They're not legal now, and they won't be in the future. And so we already know that medical marijuana or cannabis is available, and anticipating that whatever bumps are ahead for the recreational will get worked out. What information is there about cannabis and its impact on an individual? And if you go to Health Canada's website, you'll see there's a lot of information where they don't come out to support its use as a remedy for certain ailments. They'll identify that it may help, but they're very careful not to, I guess, endorse or sponsor it. They have published on their website a warning that using cannabis or any cannabis product can impair concentration, ability to think, make decisions, reaction time, and coordination, and it can affect motor skills, including the ability to drive. It can also increase anxiety, cause panic attacks, in some cases, paranoia and hallucinations. The Canadian Centre on Substance Abuse has published on its website some information about cannabis use in driving. And that body has stated that it will impair cognitive and motor abilities necessary to operate a motor vehicle. After alcohol, cannabis is the most commonly detected substance among drivers who die in traffic crashes. And drug-impaired driving, which is the operation of a motor vehicle while one's ability is adversely affected by the drug, is a criminal offense in Canada. And I think a lot of young people in particular may not appreciate that. Impaired driving is impaired driving, whether one is impaired due to alcohol or to marijuana. And the challenge for employers, for enforcement, is how to know how much one is able to consume or use before one is impaired. And that challenge is due to the fact that, first of all, there's no current reliable test to measure impairment. There's talk about a saliva test that can be used roadside, such as the alcohol testing roadside. But based on conversations I've had with OPP officers, it's not a given that the saliva testing will be implemented to test for cannabis. So there's no one universal reliable test. There's also no one universal level of THC, the active ingredient in cannabis, that the authorities agree means that one is impaired. Also, it can stay in your bloodstream for up to 30 days. So one could measure that they have this in their system, but it might not mean that they're impaired. And it really does matter with respect to individual physiological makeup, size, weight, fat cell content. Everybody reacts differently to the substance. The College of Family Physicians of Canada, and this was in the context of when I was doing a lot of work on medical marijuana, that college made recommendations for physicians to consider when prescribing medical marijuana. And patients taking dry cannabis were advised not to drive for at least 4 hours after inhaling, 6 hours after oral ingestion, 8 hours after inhalation or oral ingestion if the patient experienced some euphoria. Health Canada stated that the ability to drive or perform activities requiring alertness could be impaired up to 24 hours following a single consumption. So we have these sort of guidelines out there that have a wide range, but it's clear the message is using marijuana will impair your ability to operate a motor vehicle. The time between use and driving is subject to debate.
And really going back to what you said before, and I think this kind of leads into this piece, but under what the government is hoping to intend is that people utilize this in their personal time at home. But then, and so really there would be no issue or problems or anything like this, given that if there's enough time. But you know, human behavior is that it's not going to necessarily look like that too, right? And what I mean is like it could happen in first thing in the morning before going to work, and then all of a sudden they're now driving or things like this, right?
Yeah.
So.
And that's where, yeah, the experience we'll have to wait and see what it really is similar. A good analogy is alcohol. It's legal. You can enjoy it. You can enjoy it in licensed establishments. We're not expecting to see that in Canada, not at least now. So it will be in the privacy of your own home. But yeah, you have to use it responsibly, both in terms of then operating a vehicle to get to work or wherever you're going, and then at the workplace.
And then actually,
yeah. The medical standards for drivers, the Canadian Council of Motor Transport medical standards, this sets out other standards that doctors look at when they are determining whether one's medical condition should trigger a license suspension. And in that document, it provides that drivers using medical cannabis should be advised not to drive for at least 5 hours and preferably 24 hours after use. Drivers using medical cannabis in excess of the average usage rate of 1.5 grams or 2 joints a day should be counseled to avoid overconsumption. And this is one of the issues with medical marijuana. You've got prescriptions, but are people following the dosage that the doctor prescribed? And that individual assessment regarding impairment and habitual use and dependence. The other issue with medical marijuana, which obviously will be one for recreational, is it's one thing to enjoy it like a glass of wine, but at what point does it become some kind of dependence or substance abuse? And of course, we know in the US, they've made things quite simple. It's zero tolerance. When we talk about commercial drivers going into the US and commercial drivers in the US, the Federal Department of Transportation, the DOT there, has mandatory drug and alcohol testing, which allows our Canadian drivers to also be tested, given that they have to travel into the US. When it comes to medical marijuana, they will not certify any commercial drivers who take medical marijuana. It's zero tolerance. And we have to keep in mind, if the drivers, if it's recreational here and it's permitted and it's a commercial driver who's subject to the random drug and alcohol testing, they can test positive and not be impaired. So it really is a challenge for the individual drivers to, and their employers, to determine, you know, how recreational marijuana may impact their ability to travel, even if they're not impaired.
And in the US right now, is it handled like alcohol in the sense of if you're caught and you're test positive that you are just basically not able to operate your vehicle?
I, I, I don't know this area as the details. I could tell you generally when it comes to commercial drivers, if there's random testing and there's post-incident testing. If one tests positive, then one is taken off the road. So I'll just talk about in that workplace context. I don't know about, I assume it is very similar in terms of just anybody operating a motor vehicle while impaired, there are consequences for driving
Sure.
under the influence. But from a commercial context, if one is working as a driver, if you test positive, you're taken off the road, and there are certain steps one has to do to demonstrate the ability to qualify to go back on the road. So there's serious consequences. I think you can ask for a second test. There's a whole regulatory regime that the US follows to ensure the accuracy and the fairness of the testing. But if you test positive, it's you can't drive.
Okay. And Vic has asked a question down here. Can a Canadian trucking company create a drug and alcohol pool for drivers, same like DOT regulated carriers have?
Very good question, Vic. There are cases that if there's a chance that your drivers will go into the US, then that does give the carrier the opportunity to do drug and alcohol testing. But stepping back in Canada, the basic general rule is it's rarely permitted. So I think that's a question that could lead to a more in-depth conversation, because if you're not going to the US at all, if you're just a local carrier, I mean, there's a very good argument. Why should we be able to test cross-border drivers and ensure that they're not impaired, but our own local drivers, we're not able to? So there's a good argument, but there's some other things that might go into the mix. Hopefully I'll touch upon some of them in the next little while, and if not, I'd be happy to continue the conversation offline.
Yeah, thanks for the question, Vic. And of course, now we're coming into this next slide, and this is where we keep really encouraging questions, because now we're getting into the actions for employers.
Right, and Vic, you've raised a good point about so the US has this regulation, and that permits the drug and alcohol testing of the US drivers and Canadian cross-border drivers. We do not have the same requirement or legislation in Canada. And there is a recent case that you may be familiar with involving the TTC that came out last year. And in that case, there was a move by the employer to implement random drug and alcohol testing as part of its fit for duty policy. It's a unionized workplace, and the union objected to that policy on the grounds that randomly testing the employees was a violation of their privacy, and that there could be some potential human rights issues that I'll go into in a little more detail generally. But you know, if it reveals an substance abuse issue, then that raises human rights concerns. So the union sought an injunction to stop the implementation of the drug and alcohol testing. The court allowed the testing. It's pending the outcome of the arbitration that the union and management are currently undergoing. That's been going on for years, and there's no end in sight. But the injunction was not granted, which means the employer could implement random drug and alcohol testing. And the reason the court allowed it in this case was twofold. The employer was able to demonstrate that there was an issue in the workplace with drug and alcohol abuse. And so the rationale being that if you have the random testing, you could, that hopefully would act as a deterrence, so that if those employees who were maybe abusing or are drinking too close to their shift, that they would be discouraged from doing so if they could be subject to random testing. And the other component that allowed for the random drug and alcohol testing was the safety-sensitive workplace. And the court made a comment that the TTC, basically the workplace is the entire city of Toronto, because we operate the streetcars, the buses, the subways throughout the city. So For those two reasons, the court allowed random and drug alcohol testing. And so that's why, Vic, I think that deeper analysis needs to be done before you implement a random drug and alcohol testing policy for Canada-only employees. It's not impossible, but it needs a little more analysis. And the TTC case is a good example of one where it was allowed. And so, as I touched upon in describing the TTC case, there are privacy rights when it comes to individuals. So requiring random testing is a form of medical examination, and in Canada we protect individual privacy rights, so that's one of the arguments against the random testing. There's also medical information that the employee has the right to protect, and I'm referring there more to medical marijuana. You balance those employee privacy rights with an employer's duty under the Occupational Health and Safety Act, or that part of the Canada Labour Code that governs occupational health and safety. So the employer has a duty to protect the health and safety of the workers and to protect public safety. And so when you balance the employer's obligations with safety and the employee's rights to privacy, what are you to do? I think the best thing to do is to have a very clear workplace policy that outlines the duties and the protections and obligations of both employers and employees. And so that is what we call the fit for duty policy. And every workplace should have a fit for duty policy. And this is not new. This is something that every workplace should already have. The legalization of marijuana is just a reminder that it is important to have a fit for duty policy, but it really doesn't change the landscape. Employers have always been able to ensure that its employees come to work fit to perform their duties. So now is a perfect time to, if you haven't got one, to draft one, whatever happens with the timing of the federal legalization. And if you do have one, take it out and take a look at it and make sure it's broad enough that it will capture recreational marijuana once it becomes legal. And one size may not fit all. You really do need to consider the individual workplace, because if there's any suggestion that the fit for duty policy may impact an individual's human rights, the employer needs to be able to justify why it implemented the policy with the terms and conditions set out in the policy. So if you are a nice office like this where people aren't operating heavy machinery, your fit for duty policy is going to look different than a manufacturing plant where people are operating heavy machinery, or forklifts, or a trucking company where you're sending people out on the road behind the wheel. So you have to be careful not to just cut and paste or copy another workplace's fit for duty policy. It's a good starting point, but really consider your own individual workplace and how the policy really needs to work in that workplace.
And so in that too, is it a, you can have distinctions. So if you had a workplace like this plus a manufacturing arm, you would have two different fit for duty policies riding together? You
could do that. You could do one fit for duty policy, and then you can carve out certain additional obligations for those who perform in safety sensitive roles. And so we're going to talk now about some of the key things to put in the fit for duty policy. And I put in defining medical cannabis, and we may also want to think about how we define recreational cannabis, because if it's just you can't come to work impaired by alcohol, that's easy, but impaired by illegal drugs. Okay, well, medical cannabis is not an illegal drug, and recreational cannabis is soon not to be an illegal drug. And then it's not even a drug as that word is defined under certain benefit plans. So you want to make sure that the language you use about substances that one cannot use before work or at work, you want to make sure it's broad enough that it does capture all possibilities. So you can identify medical cannabis, recreational, mood-altering substances that are not illegal. You know, you can see where this is. This will take some wordsmithing to really make sure that you've defined the types of substances that the employer does not want brought into the workplace, or for one to be impaired by using them shortly before reporting to work.
And just really quick here, Kim is asking what the acronym ACMPR is.
Sorry, that is, thank you, Kim, that is the regulation that we reviewed in the very first slide, and I don't remember exactly what it is. It's the regulation that that allows for one to access medical cannabis.
We won't go back to find that.
But that's it. So it's just really trying to make sure that we're tying it to what is, it's medical cannabis. You want to make sure it's not self-prescribed. It's one that you've got.
I can jump up here. So is it in this slide?
It's in the next slide, I think. The first regulatory. There it is. Access to cannabis for medical purposes regulations.
Okay.
So that's what I was referring to. You want to define fitness for duty, and you want to, this is to your point, Kyle, you want to identify obligations on those who hold safety sensitive positions, because they, in particular, you may want to impose greater reporting obligations on those employees. And again, as I said, that's why you need to look at your workplace, because you want to be mindful of human rights, and you have to justify, why am I requiring certain people to report certain things, and it's linked to the fact that they're operating heavy machinery or they're in a safety sensitive position.
And actually, just another question that I have. If for some reason an employer wanted to almost come from the complete opposite angle, like imagine I don't know, so whatever business you have, let's say a tech company or something like this, and they have a bunch of programmers, and they want to provide free will to their staff to do whatever. Can they also create that type of policy?
That's very interesting. I guess that I hear what you're saying. Those Google type workplaces where everybody's playing paddle board or whatever. A couple of things the employer would need to be aware of if it again be like drinking at work. I mean, there are some workplaces where you'll go for lunch and you'll have a drink. That's not a big deal, or you'll celebrate something in the office. The employer needs to think of a couple of things. First of all, I think the employer would need to think about the Ontario regulations. Like, you can't smoke cigarettes in an office, so you're not going to be able to smoke marijuana in an office. You've also got a liability issue. If you're not discouraging, I won't use the word encourage, but if you're not discouraging people from partaking in recreational marijuana while they're at the workplace, and then they go out to drive home or to drive to a client's place, you as the employer may bear some, it's the old host liability cases that we saw many years ago, where the host who overserves alcohol to his or her guests can also be liable if they go out and are impaired and are involved in an accident. So there's always, freedom of contract, and you're the employer and you can manage your workplace, but you do have some liability issues, I think, to keep in mind. And also, what are the regulations governing the workplace? And there are strict smoke-free workplace regulations that will extend to marijuana.
Okay.
So with the key provisions, one, what do I mean by fit for duty? All employees are expected to be fit for duty when reporting to work, remain fit for duty for the duration of their shift, and must not be impaired by recreational drug or substance, prescribed drug or substance, or alcohol. So that's one way to sort of very generally and broadly capture what the fit for duty requirement is. The employer is able to prohibit consumption and possession of recreational cannabis at work, just like the employer can now do that with alcohol, and require employees to report to management or a certain person in the workplace if they are concerned if a coworker is not fit for duty. And that is important, and it goes to the employer's duty under the occupational health and safety laws to ensure a safe workplace. I don't see any reason why you can't include in the policy a duty on an employee to disclose to a designated person that they have a prescription for medical marijuana or any other prescription medication if the employee is employed in a safety sensitive position, or the employee's experience with the prescription medication, whether it be cannabis or something else, may cause impairment to their ability to perform their jobs or could compromise the safety of others in the workplace. And so that is a duty that, again, you want to be able to justify it in case somebody argues that it's a breach of their privacy or there's a human rights issue. You're justifying it because of either safety sensitive position or impact on safety in the workplace. And you'd want to be very careful that if you would create this duty, that there is the privacy component to it. That's why there's got to be a designated person that that the employee would disclose this to, and that it would be kept confidential. You also want to include in any policy to address those human rights concerns that the employer will accommodate any disability to the point of undue hardship. And I raise that because the medical prescription could be due to an underlying disability. Disability is very broadly defined in our human rights laws, both federally and provincially, and it includes a wide range of things. So chances are, if an employee has a prescription for medical cannabis, there is an underlying disability. The other circumstance in which accommodation could arise is, as we mentioned at the outset, the use of marijuana or alcohol or prescription drugs may become an addiction or substance abuse. And those conditions are also considered a disability. So if an employee, if through the Fit for Duty policy, it comes to light that an employee has an addiction or substance abuse, that's a disability, and you have to accommodate that employee as the employer to the point of undue hardship. And you may want to put into your policy that you will, well, you should put into your policy that you will accommodate, and you may want to put in that medical information may be required. And we'll talk a little bit more about that when we get to duty to accommodate. Lastly, you want to set out in your Fit for Duty policy what the consequences are for non-compliance, and that they would include discipline up to termination. And again, the challenge for the employer is going to be, if it's just recreational use, there's no addiction, and they continue to show up, not fit for duty, or at lunchtime they abuse the policy and imbibe, then if there's no human rights element, then you may be able to discipline them and terminate them. But if the violation of the Fit for Duty policy is due to a human rights disability, then you may not be able to discipline them or terminate them, because that would be a violation of human rights. You have to accommodate them. So for that reason, the consequences, you have to set them out somewhat in a permissive way, not if you breach the policy, you will be fired. That breaches one's human rights. If you breach the policy, you may be disciplined and you may be terminated. Using the word may gives you that ability to undergo the individual assessment. Is this really willful misconduct in violating a workplace policy, or is this something that requires accommodation?
Great. And just so we want to really respect people's time, so we have about 1 minute here in the stated time.
Okay.
But this next, like where we're moving, is an area of importance and I think of interest to the people watching. So what I'm going to ask is, obviously you will receive a recording of this, but we're going to extend by 5 minutes and go to 10:45. If that works for you.
That's great. And I think we've covered some of the points that on this slide about the duty to accommodate. So it's to accommodate an employee up to the point of undue hardship. Lots of cases about what does undue hardship mean. and it's very onerous. It's the employer who must show undue hardship. So financial impact is not necessarily considered undue hardship. Um, so and what are let's talk about what I mean by duty to accommodate. So if we've got a truck driver who goes to the U.S. and uses medical marijuana, you could take him off the road. He's not going to be able to pass the U.S. random drug testing with zero tolerance down there. Oh, and by the way, in Ontario, there's a recommendation for zero tolerance for commercial drivers for drug and alcohol. That's an amendment under the Highway Traffic Act. So let's look at that example. Medical marijuana due to a disability, take him or her off the road. And how would you accommodate that person? You would, depending on the size of your workplace, one way to accommodate is to give them a non-driving assignment while they're having to use this method of medication, or you give them a leave of absence while they're managing the underlying illness that has led to medical marijuana. Depending on, and the duty to accommodate is a two-way street, so the employee really needs to cooperate with the employer and may need to provide more medical information. One question for the doctor could be, did you know that this patient is a driver and these are his duties and responsibilities, and is there another medication that could be prescribed? And sometimes the patient isn't telling the doctor all of the information, so the doctor's prescribing something without understanding the impact. And as I mentioned a moment ago, with recreational marijuana, its use on its own is not protected by human rights laws. So if someone wants to use it, but does so in a way that breaches company policy, that's disciplinary, that's grounds for discipline. If they use it and really it's part of an addiction or abuse, that's when the duty to accommodate is triggered. So with respect to what information can you ask for from the employee in order to discharge your duty to accommodate, you're not entitled to a medical diagnosis that has led to the medical cannabis, or in the case of a substance abuse, the employee would have to acknowledge that they have that type of disability in order for you to know that they need accommodation. I assist employers with managing accommodation all the time, and I have developed a questionnaire that an employer can have an employee present to his or her doctor that sets out the kinds of information, the type of information that you're entitled to in order to engage in this process and determine whether you can accommodate to the point of undue hardship. And so that's something that you are entitled to, more than the doctor's note that says person A is away for 2 months, we'll see them again in 2 months. You can ask for some more information, but you have to be careful because you're not entitled to, as I said, the diagnosis, but you are entitled to know prognosis. Is there a way to bring them back earlier? There's lots of information that you can get that you're legally entitled to. And as I say in this slide, that you are entitled to confirmation that the employee has a disability and that the medical cannabis is required to treat the disability.
Abby has a question. Is it against privacy to ask a potential employee about their use of recreational cannabis?
That's a very, well, it's not a protected ground. So what I'm getting at there, Abby, is you can ask questions in pre-employment so long as they're not discriminatory. And so using recreational cannabis is not discriminatory. It's not protected the way do you have a glass of wine on a Saturday night is not protected. So I think though you'll get some creative unhappy person out there who didn't get a job who might try to raise some potential privacy issues. I think you have to be alive to why are you asking this question. If it's because you're hiring somebody for a safety sensitive position or to drive a commercial motor vehicle into the US, you can link it um, to a requirement that's related to the job. And I think if you did that, that you may be able to justify asking that question. I think it has risk, but as I said, what jumps out at me is it doesn't violate human rights. And I don't know that it violates privacy. But I think you'd be best to limit that question to only applicants for jobs where that might be an issue, i.e. the cross-border driver.
Okay, next slide. And look, I get we are at 10:45 right now, but this is really good value. And so we just want to make sure we capture the rest of this so we don't leave people missing the final
Waiting
piece.
to hear. Yes, and we're almost there. Again, with the medical marijuana entitled to, or even a prescription drug entitled to the dosage amount, frequency, form in which it's taken. To sort of finish off the point I started a couple minutes ago, the medical information that you request has to be the least intrusive of the employee's privacy while still allowing the employer to be able to make an informed decision. And that's where this medical questionnaire that I've developed is a good tool to achieve that. If an employee's doctor provides an opinion that an employee is able to operate machinery or a vehicle while under the taking medical cannabis, I would proceed with caution. I would not accept that driver's, that doctor's knowledge, that doctor's opinion, unless you really want a physician that's knowledgeable in occupational health and safety and the interaction between cannabis and that. And it may trigger your right to seek an independent medical examination of the employee, which is not always possible for employers to do, but that might be a way to address that. And I've already touched upon this of what can you do if you do have to accommodate an employee who either is using medical cannabis or who has a substance abuse issue that's revealed once the legalization occurs. You either move them to a non-safety sensitive position if your workplace can do so, or put them on a job protected leave of absence. You don't have to pay them. They can access workplace benefits if they're there. Otherwise, you issue them a record of employment saying off due to illness, and they can access the employment insurance regime. So that's another way to accommodate an employee who's not able to work due to a disability. And I think we've covered all of these. The last point I think that I want to leave you with is how do you implement the fit for duty policy? So if you've got one and it's in place and it's great, you don't need to change it, now might be a good time to retrain your drivers on the policy. If you're introducing a new one, then here's how to implement it. And if you're tweaking an existing one, here's how to implement it. You must ensure that all of your employees are aware of the policy and understand the policy, including what the employer expects, what the employee's duties are, the fact that there is the ability to seek assistance or accommodation if there's an abuse or a disability, and that the employee understands what happens if the employee does not comply with the policy. And the Supreme Court of Canada released a decision last year, Stewart and Elk Valley Coal, which many of you may be familiar with. That was a case that upheld an Alberta Human Rights Tribunal decision, which found that an employee who had a cocaine addiction was not dismissed because of his addiction, which would have violated his human rights, and he would have been entitled to damages and possible reinstatement, but he was dismissed due to a breach of a workplace policy. And that was not discriminatory, and therefore the dismissal was upheld. So very quickly, it was a mining company. It implemented this policy to ensure safety in the workplace, and the policy encouraged employees that to come forward if they had a substance abuse issue, to come forward and get treatment, and to do so before there was a workplace accident that revealed that there was an issue. And the policy said if they did not come forward and they were tested positive post-accident, that their employment would be terminated. So that was what the policy said. It was very clear what the consequences were, and it encouraged support if you self-report. And that's what happened. The employee tested positive for cocaine following a workplace accident, and he then claimed that he had an addiction, being a disability, and therefore entitled to human rights protections. The court held that the breach of the workplace policy was the true reason for the termination, not the addiction. And what was key to the court's decision was that the policy was clearly worded, that the employees were trained on the policy, and that they had signed an acknowledgement that they had been trained and received a copy of the policy and understood the policy. And based on that, the Supreme Court upheld the termination. So that's a perfect illustration of, it's one thing to develop a great policy, that's half of it. The other half is making sure your employees are aware of it, they understand it, and they've acknowledged receipt of it. And that way you can then turn to it to address non-compliance. And I think, Kyle,
yeah, that's it. And just on that too, so that would actually potentially, because sometimes policies come out and it just says, please acknowledge that you've seen this. This would actually potentially look like something bigger than that, where you sit down with the staff and do it.
I don't see why you wouldn't do that. I think that's best practice really for all workplace policies. I hear what you're saying, that there are policies come out all the time, you know, click here that you've read it. But I think something as important as this should be definitely dealt with. You could have a safety meeting. It could be in a safety meeting. It could be, you know, groups of employees. But I do think that the best practice would be to truly review it in detail with employees face to face, so they also have the opportunity to ask questions.
Great. Okay. And that's it. We are now complete. So thank you. This was wonderful. So thank you for giving us your time. If anybody does have a question right now, feel free to type it out, and we will answer before we close out. That is Carole's email address right there. And in the follow-up email that I send out, I'll also include her contact information there. So if you do have a question, she's agreed to help see if she can answer that for you.
Absolutely, yes.
Vic, it looks like Vic is typing something, so we'll wait 1 minute here before we close that down. And we will see. Do we get a copy? Yes, we will send out a copy of the PowerPoint with this, and we'll also include another sort of summary document that covers off pieces of this, but not to this depth. Any other questions? Okay, so it's at this point we will close out this webinar. Thank you again.
Thank you. Thanks everyone for your time this morning.
Thank you guys. Have a nice afternoon.